No.
Okay, so what happened?
Just in here, take away the perfume. I love perfume. Stupid decision. Only.
Why?
Not that you love Carol. I know this man nice. Sometimes I buy because I have Macy's card. Sometimes I buy and sometimes I take them.
Okay. So you've done this before?
Yeah, in this store.
Yeah.
I never.
Okay, no more nice guy. Where's the key?
You have them on you. No shit.
Nice. You just lost all the trust. Good job.
On June 1st, 2023, officers in Colorado responded to a reported retail theft at a department store. This analysis focuses not on what happened, but on whether the law was applied correctly.
Good, how are you?
Good.
What's happening?
Look at you again.
What's up?
So? She stole.
No.
That's it.
That why we're here?
Yeah, done.
Say less. All right.
Matching outfit. But there's a thing though. So she has some stuff.
From other stores.
No. So she took some stuff from us. She left, dropped it off in the car, came back.
Okay.
Yep.
Okay.
Hello. Hi. All these fragrance bottles.
How much are you looking at?
972. 972.
Girl, 972.
And she's
Oh, there's
a
a
repeat
picture.
offenders for us.
What's that?
I just
Oh.
don't know if we've made a police report on her.
What happened?
Say less. I'm gonna go read her and I'll figure it out.
She conceals the slippers and the white pants inside the fitting room. I was there because when she came out, the merchandise was gone, but she wasn't feel sure about it, so I was like, okay, let's just let her be. But that's what she concealed inside the room.
She's
Just putting it in her bag.
Yeah, she put it all in the pink bag.
The red one?
Yeah.
Did she buy something too?
Yeah, so
From
she
the
paid
Mason?
for a couple of things and then with the merchandise check. And she takes that one, puts it in the bag.
She paid for stuff, then starts walking around the store and
Yeah, she only paid for one shirt.
open.
That's it. And then she has it and then she conceals it.
Question. Have you ever had her arrested before? No? First time? When you say repeat offender, I'm thinking like,
what I said, repeat offender.
oh my gosh. This Macy's is going to be the death of me.
That's fine.
1214 JV US.
Oh, it's unbelievable. It's great. It's great.
The first legal issue is probable cause for detention. Loss prevention documented the theft on security video and provided a direct eyewitness account to responding officers. Under the Fourth Amendment, this satisfies the probable cause standard established in Illinois v. Gates in 1983, a totality of the circumstances analysis. Both independent surveillance footage and a live witness account were present before any detention occurred.
Forgot about that.
Yeah, thank you.
And what's her name?
She did some dumb shit cooking stuff.
Okay. So I'm gonna talk to you because I'm the one who's gonna take this. So I have to read this to you before we talk, okay? So you have the right to remain silent, do you understand? You can say yes or no.
Yes.
Anything that you say may be used against your court, do you understand?
Yes.
Alright, you have the right to talk to a lawyer before and during questioning, do you understand?
Yes.
Alright, if you cannot afford a lawyer and want one will be provided for you before questioning without charge, do you understand?
Yes.
Alright, has anyone threatened you or promised you anything to get you to talk to me?
No.
Okay, so what happened?
Just in here, take away the perfume. I love perfume. Stupid decision. Only.
Why?
Not that you love Carol. I know this man nice. Sometimes I buy because I have Macy's card. Sometimes I buy and sometimes I take them.
Okay, so you've done this before?
Yeah, in this store.
Yeah. And you
That's
just,
what, yeah, just sometimes I just buy and take them and spray them on me. Sometimes I eat them.
The second issue is Miranda compliance. Before questioning, the officer administered all 4 required advisements: the right to remain silent, that any statement may be used against the suspect in court, the right to consult an attorney before answering questions, and the right to appointed counsel at no cost. The Supreme Court in Miranda v. Arizona, 384 United States, 436, established that custodial interrogation, without these warnings, renders any resulting statement inadmissible. Here, each element was confirmed individually. The officer also asked whether anyone had threatened or promised anything in exchange for cooperation of voluntariness, confirmation that satisfies the knowing and intelligent waiver standard. The third issue is the scope of the waiver. The suspect did not invoke. She waived and answered questions freely. Under Colorado v. Spring 479, United States 564, a Miranda waiver remains valid. Even if the suspect did not anticipate every subject of questioning, her admission to prior thefts at the same store, made voluntarily after a valid waiver, is fully admissible as evidence of a pattern of conduct.
But if I took because I have a job and business card.
Do you guys want her trespass?
Yeah.
You guys have form?
Yeah, because the thing is this off and when I look at him and I put it, you gotta shoot.
How did you get here?
I got drunk off.
You got dropped off.
I got drunk off.
Do you have keys?
You're gone.
Do you care if I look?
Yeah.
Hello. Okay.
What kind of part of your...
All right. So here's the deal. They have you on video surveillance putting other children's clothes into the car.
Oh, they left, yeah.
They left? Okay. Whose car is that?
That was my friend.
That was your auntie's car? Okay.
So what happened with all these other things that you took?
What is
The
that?
shirts, some pants.
Oh, they left with it.
They already took that with them? Can they come bring it back?
Because otherwise what's going to happen is there are going to be accessories after the fact.
No, I got that. No, I paid for that.
Okay, and what about all these other things?
Oh, yeah.
Yeah. Can they bring that stuff back? Can you tell them to come bring it back?
Yes, is it nice?
Yes. Did you buy it? No.
Otherwise they're going to catch felony charges. You don't want that. Really making this harder and harder on yourself.
We asked you earlier where the keys are. And what did you say? I don't have any keys. Okay. So where? Where are your keys?
Where's the key?
I'm nervous.
Okay, no more nice guy. Where's the key? They're in your
You have them on you. No shit.
Nice. You just lost all the trust. Good job.
I was nervous.
Give me the keys.
Fucked up.
You're
I'm
nervous.
nervous.
Give me
I'm
the
just
keys.
nervous.
You're like a pro at this. You've done this like 5 times.
I'm nervous.
Stand up. Stand up.
I'm
Turn around.
nervous.
Turn around.
Sorry, I was just
Turn
nervous.
around.
I was just nervous.
You were good. You lost it.
I was just nervous, sweetie. I was just
They're in the back seat behind the driver's seat, right?
Yeah.
Bet.
I was just nervous.
Put your hand facing in. There.
I was just nervous.
That's fine.
Nope. No more subtle.
Mr. Sully,
We were cool. We were nice. I
Sit
tried to
down.
be cordial. You lost it.
The fourth issue is the felony charging threshold, Colorado Revised Statutes. Section 18.4.401 classifies theft as a Class 1 misdemeanor when value falls between $300 and $1,000. The Class 5 felony threshold begins at $2,000. The documented merchandise value here was $972, below that threshold. The felony charge may reflect aggregate value from prior admissions, merchandise transported by associates in the vehicle, or prosecutorial discretion based on the totality of the suspect's statements. This distinction matters. Charging above the statutory minimum for a single incident requires documented justification. The fifth issue is third-party accessory liability. The officer warned that individuals who transported stolen goods in the vehicle could face charges under Colorado Revised Statutes, Section 18.8.105, accessory after the fact. This statute requires that the person knowingly assist another to hinder apprehension or prosecution. Driving away with stolen merchandise, with knowledge of the theft, satisfies the mens rea element under this provision. The sixth issue is the suspect's deception regarding car keys. After denying possession twice, keys were found on her person. This lie carries no Fifth Amendment protection. It was not an invocation, the right to silence, but an affirmative false statement. False statements to law enforcement during a custodial encounter can independently constitute obstruction under state statute. More practically, it destroyed the cooperative dynamic. The officer had deliberately maintained a dynamic that had produced highly incriminating admissions the defense would have difficulty suppressing at trial.
Good for a second. We played this.
Can I what?
Right? Yes, by the accessories.
Okay.
He knows where it is. Let's go.
The people in the doctor, please, thanks. Get the pump. Oh, am I going to put all the people along? So where's the van key?
He's putting your big purse in there, so.
I didn't want to bring it back.
Yep, I'm just gonna bring
Yeah,
it
put
right
him on
back.
keys.
You're no kidding.
Here, widen your stance.
Eh?
Widen your stance.
Oh,
Do you have anything else on you?
no.
Alright, if you do and you go into jail, you're just gonna get in trouble and it's gonna be another charge. Okay?
Yeah. Oh, just.
Nope.
Oh, sorry.
I mean, unless you want another charge, you know. For urinating.
Drop that paper towel out of your hand.
Oh,
Drop
I want it so long.
Go ahead.
Listen, the quicker you get in, the quicker we leave. I'm gonna go to jail so you can pee.
I don't want it so long. Come on, Mom, man. I've been asking.
Okay.
I'll take water.
You take.
Keys. There's a signal for there. Alright.
I'm saying,
You can call her when you get to the jail.
so why don't you call her now so I don't stay overnight? She have a key.
You can call her when you get to the jail.
Say, can you dial the number now?
You can grab it when you get to the jail.
They're going to pull the anchor?
Huh?
They're going to pull the anchor for me?
You can make a call once you get to the jail, yes. Well, once you get processed. Echo 16, 10, 15, 10, 12 for the one of
Dial
BRC.
the number for me on my phone.
You can get it when you get after they book you in.
Miss,
Yep.
I'm saying they won't tow away my car.
We're not gonna tow it. If the mall wants to, they can, but
That's what I'm saying. Can you just, so she come grab it now?
once we get to the jail, and once you get booked in, you can call.
But it's not going to be too late.
I don't know.
Huh?
I do not know.
You can't just do me that favor, please.
Nope. You lied to us.
Huh?
You lied to us.
I know, and I tell you, I was nervous. I'm sorry.
Okay, well.
I was nervous, and that's the honest to God truth.
Okay, even if you were nervous, you still lied to us. When you're nervous, that doesn't mean you lie.
That is true, and I'm sorry.
Okay.
I'm sorry. I just want to so they could come get it.
Like I said, once we get to the jail, once you get booked in, they will let you make a phone call.
You can dial the number for me, please.
Well, see, I'll tell you what. If we get to the jail and you do not pee in my car,
I'm not, but yeah.
okay, once we get to the jail, and then after we let you use the bathroom, I will call her while we are in there, so she can pick up the car.
It's going to be so late.
It's not going to be late. The jail is like less than 10 minutes away.
Let's examine the constitutional framework. Officer grade B+. The Miranda advisement was procedurally complete and correctly sequenced. Probable cause was established prior to contact. No use of force beyond minimum handcuffing was applied, consistent with the Graham versus Connor reasonableness standard. Post-arrest communication was professional and informative. The grade is reduced from an A for one reason. The comment that the suspect appeared to be a professional with 5 prior arrests was unprofessional. Statements made to a suspect in custody about perceived criminal history serve no tactical or legal purpose and create unnecessary exposure in subsequent proceedings. Suspect grade D. The critical error was waiving Miranda and speaking without counsel. The Fifth Amendment right to remain silent is not passive. It must be exercised. Silence cannot be used against a defendant. The suspect's voluntary admissions, including her statement that she sometimes takes merchandise without paying, constituted direct evidence of intentional, repeated criminal conduct. Under Colorado Revised Statutes, Section 18, 401, knowledge and intent are elements of theft. She supplied both, unprompted, on camera. The subsequent lie about the car keys compounded the damage. Cooperation had produced a favorable tone. The deception eliminated it, without offering any legal or practical benefit in return. Lessons learned. First, Miranda waiver is irreversible in the moment. Once a suspect waives and begins speaking, subsequent statements remain admissible even if the subject matter shifts unexpectedly. The correct and only safe choice during custodial questioning is to invoke the right to counsel and say nothing further. Second, deception during custody carries asymmetric risk. A lie that fails exposes the suspect to additional charges and eliminates any goodwill that might have influenced charging decisions or prosecutorial discretion. Third, officers must distinguish between legally necessary statements and professionally inappropriate commentary. Custody creates a power imbalance. Remarks about a suspect's apparent criminal experience, however casual, undermine professional standards and serve no investigative purpose. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.